today. With us now is Kimberly Mutcherson. It's co-dean and professor of law at Rutgers Law School. It's good of you to be here. Thank you.
Thank you.
Your top-line thoughts on what we've seen and what's to come.
We were expecting this. We knew that it was going to come down. And now that it's here, it is exactly as disastrous as I imagined. And I think that a lot of people imagined, particularly the concurrence from Justice Thomas, which makes clear that this idea that this is just going to be cabined to abortion and let's not worry about all these other rights is just a farce. We have a lot to be worried about in the years to come. Of course, that's what he said, right? And that's very easy to say that in the same way that, Justice Kavanaugh and Justice Barrett told us that Roe versus Wade was settled law and stare decisis meant that it was going to stay that way. And yet here we are.
Back to that. Is there any gray area? I mean, I've gone back and looked at their testimony during those hearings. It didn't feel like a gray area from the two whom you mentioned.
Yeah, no, I think that's exactly right. And I think that people, they get prepped for these confirmation hearings. They know what they need to say in the confirmation hearings.
Then what is the point of the confirmation hearing if you're not speaking, as you suggest, if you're not speaking your truth, but instead saying, as you put it, what you need to say?
I think one thing that we should know, particularly after watching the confirmation hearings for Justice Jackson, is that they are theater at this point, that they're not really about trying to assess whether someone is going to be a good Supreme Court justice. They're about scoring political points.
Are there cases, Professor, that you see in the pipeline that people should watch more closely? Are there cases that regarding gender or race or sexuality or anything that might give us a little more of an understanding of where this court is going?
I think we know exactly where this court is going. There are some affirmative action cases that are going to be heard. I know where I would put my money in terms of how the court is going to come out on those cases. I'm worried about what some of the future contraception cases might look like. And I think that this court has made very clear that it is very willing to reinforce First Amendment rights related to religion. And so that, again, is going to create an opportunity for a lot of other sorts of inroads into reproductive rights.
Professor, help me understand from a legal perspective, what about today's ruling suggests, as you put it, that rights to contraceptives might be changed?
So, first of all, in the concurring opinion from Justice Thomas, he clearly points to Griswold versus Connecticut, which is the case that extended the right to contraception to married couples, followed by Eisenstadt versus Baird, which extended it to single people. And those cases are derived from the same idea, right? The idea that the 14th Amendment has a substantive component that creates particular rights, including a right to privacy, under which a lot of these things fall. So contraception is absolutely on the chopping block here.
If contraception is on the chopping block, are interracial marriage on the chopping block? Is same-sex marriage on the chopping block? Is all of this on the chopping block? And you're coming at this from a liberal perspective, I would presume.
I'm coming at it from a liberal perspective in the sense that I'm coming at it from the perspective of people who have often been vulnerable and marginalized in this country, for whom the Constitution is an incredibly important document and needs to be a living document in order to protect those of us who have often been on the outskirts of protection in this country. So from that perspective, I have very serious concerns about what it means to decide that all of these sorts of issues should be sent back to the states. I don't think interracial marriage is particularly on the chopping block, but certainly marriage equality from the Obergefell case. I have very serious concerns about that. And that's another case that Justice Thomas specifically points out in his concurring opinion in the case today. So, again, this idea that this is just about abortion is ludicrous, that we are at the beginning, not at the end. And we're going to see a lot of legislation and a lot of litigation in the months and years to come to try to figure out what does it really mean to be a person who is protected by the Constitution in this country.